Okay, we're back on the record on State versus Loyd. Mr. Loyd's present with his attorneys. He's tired as he was this morning, except he's back in shackles. The stun cuff has been removed. The shackles have been replaced on him. His feet are underneath the table, cannot be seen by any angle, from any angle in the courtroom by the jury. All right, Mr. Ridgway, you wanted to talk about your proposed rebuttal? Go ahead.
Your Honor, we'd like to call Detective Pete Cadiz, who was the lead investigator on the Dixon, the Clayton homicide, and through him to introduce 2 Walmart surveillance videos. The first one is the entire video, that a portion of which was introduced by the defense. They stopped it about 5 or maybe less than 10 seconds from conclusion. The second video is the completion of the sequence, which was taken from another angle. And I know the court has seen both of these in their entirety.
When you say the completion of the sequence, are you talking about the sequence of the shooting?
Yes, the final sequence, which shows Sergeant Clayton laying in the driveway.
All right.
In their opening statement, the defense has announced that they're going to rely on the defense of self-defense and that Sergeant Clayton fired the first shot. In support of that claim, they've introduced the testimony of Ms. Cox about the defect in the window. They've introduced the projectile that was found that she testified could have been a ricochet from that defect, and the video, all in support of their claim that the defendant is acting in self-defense. The best evidence of his state of mind is what he did. And to simply cut the video off at the time where the part that supports their case and doesn't show the next few seconds of what the defendant actually did leaves this jury in the dark about what he did, and that it is in effect misleading. I simply want to complete the video. The second one is separate. It shows again what he did after the shooting. The entire sequence, we're talking about maybe 10 to 15 seconds after the defense video cuts off. I want to finish the sequence.
Thank you, Mr. Ridgway. Response?
Judge, this is intended to make this a feature of the trial. And first of all, Judge, if you look at the video that we introduced, which is the third sequence of the events, what is portrayed in that video is that my client is running unarmed through the pillar area, and Sergeant Clayton is giving chase with her arm extended. We intend to argue that she fired a shot at him and that shot hit the south part of Walmart, and that the projectile was recovered was indeed from her gun, even though there was absolutely no match. What you also see, which is completely in dispute, and to show how they're leading the court down the road of feature of this trial, is that then you see my client pull out his gun and point it at Sergeant Clayton, and you see her trailing away, like she's running away with her back towards my client with her gun pointing. That's what's seen in the video that we introduced. So for them to say that it color coats my client and his actions is completely inaccurate based on the video. Importantly, the limited issue that the court allowed this in was for identity, and we're talking about the Williams rule, or consciousness of guilt. Our argument is that he fired in reaction to her firing, and that is when he became, even within our own video, apparently the aggressor, because now she's moving away from him in the video that we introduced, and he has the gun extended at her. So there is no issue about the aftermath of who becomes the aggressor and what is happening in the video. It's not being distorted. It's actually not in favor of our client. The point that we made with the video is that he only drew when she had fired at him or appeared to be pointing the gun in his direction. So essentially the evidence is her pointing the gun in his direction, him coming around, he essentially pushes the car towards her, she breaks this way towards him, he's unarmed at this point, he breaks away, he goes around the pillar, and that's when she is depicted in the video with her arm extended at him, which we believe she fires at that point. The projectile hits the south end, that's what's recovered. And then at that point, when he hears the shot, is when then he pulls his gun out and becomes the aggressor. And you see that on our video. So it's not depicting, it's not color coding his reaction or distorting that at some point, even in our video, he becomes the aggressor, because her back is to him at that point, and she's running away with her gun pointed behind her. And that's what's seen on the video, Judge.
So are you going to use that to argue that he was defending himself, that this was self-defense?
No. I'm going to argue that he did not have a consciousness of guilt. I'm not asking for any instructions. I'm arguing that he had a consciousness, he did not have a consciousness of guilt, because when he pulled out his gun, it appears that she is pointing her gun at him beforehand. And then the connect the dot, meaning you can either believe or disbelieve the evidence that this projectile that was recovered belonged to her gun. It did not belong to his. And the expert, their own expert, says you can't exclude it from the Sig Sauer. And that defect was present on the day after the shooting through the testimony of Ms. Cox.
So I just want to be clear on what your argument is. So your argument is that he wasn't trying to evade? I'm not really clear what your argument is. Your argument is that he wouldn't have pulled his gun if the police officer hadn't pulled hers and said, "Stop, get down"?
Fired.
I can't follow your argument. So
the argument is to your allowing the introduction of consciousness of guilt. So the
Right.
question is, can the jury use this information to show consciousness of guilt in the Dixon case? And my argument is that him running away from her in and of itself is not consciousness of guilt.
it's because she pulled a gun and fired.
Yes. No, because he ran away from her before she pulled the gun and fired.
Okay,
Or at least before she fired.
okay.
So when he was fleeing from her initially, that wasn't consciousness of guilt. He's trying to get away from the police officer. Obviously, he knows he has a warrant. He hasn't turned himself in. He's
Okay.
trying to get away from her. It isn't until that she fires at him what appears to be the action of firing, because he didn't testify, and certainly I didn't put on any testimony other than Sturby, who says that he believes in his initial statement she may have shot first, which he
Okay.
told that to the detectives.
Right.
So then the issue of him pulling his gun and becoming the aggressor isn't consciousness of guilt he's in fear for his life.
Which is self-defense.
I'm not asking for a self-defense instruction.
Okay, State, you get the last word. Were you done? I'm sorry. Was that the end of your argument?
Yes.
Okay. State, you get the last word if you want to.
Judge, I think that if the question is who fired first, I think Mr. Linneman, when he acknowledges there's no direct evidence of who fired first. There's no sound on the video, so of course that doesn't tell us who fired first. You cannot tell by the movement of the firearm or anything else. There's nothing affirmatively on the video that shows who fired first, that she fired. They have this circumstantial evidence. And as to Mr. Stribbe, what he in fact said, as he read to Mr. Linneman, was, then I see the police officer's gun. I think the police officer shot first. I'm not sure who shot first. It might have been the police officer. It might have been the guy. So he does not say she shot first, just that she may have. So if the question, we've then become a circumstantial question of what was happening here and who was doing what, and what happens in the next 5 seconds or 10 seconds less after that encounter is evidence of what happened and the state of mind and the intent of the defendant. And I think to deprive this jury of at least that part of this story is unfair to them and not fair to the state, who's entitled to have its case presented as well as to here's what happened in that case.
Mr. Ridgway, the court understands the state's frustration with the situation and the defense having introduced only part of the video. I anticipated that you were going to ask to introduce this earlier, quite frankly, so I went back over the case law on this. And my concern remains the same as it was when I first excluded the tape, which is that video of a police officer being shot. I'm not going to describe the video for everyone, but we've all seen it. We know what's in it. Is just something that I don't believe, if we played it for the jury, I just don't see that there'd be any way for that not to become a feature of this case. And I'm going to stand by my original ruling. Is there something else you wanted to put on the record?
Your Honor, just that since I pointed out there's 2 videos. There's the one the court just made reference to, and there's the one, the completion of the video that the defense started to play, which shows that the officer fell, and it shows the defendant running over there, but it doesn't show what happened next.
I think that the jury would have to be asleep to not figure out what happens next, since she's on the ground when the final bullets are fired. And what you're asking to play, I understand what you're asking to stop at, but it would be Mr. Loyd standing over her while she's on the ground with his gun pointed at her. Again, I sympathize, I do, but I just cannot allow that video to become a feature of this trial. So, do you have any other rebuttal?
No, ma'am.
Mr. Schwartz, you have a motion?
Judge, we'll renew our judgment of acquittal. We'll also adopt the arguments we made at the initial JOA. We'd like to add in that at this point, the state's evidence is legally insufficient to rebut the defendant's testimony, which established self-defense. This includes the counts 1, 2, and 3, the premeditation, Judge. As I said, the defendant's testimony, which established self-defense, isn't rebutted by anything that the state's presented here. Regarding counts 4 and 5, again, the state's evidence is not sufficient to overcome the defendant's testimony, which establishes self-defense here. Regarding 4 and 5, you also have the issue with the circumstantial evidence that the state presented showing, or which they used to argue that this should sustain our previous argument, stating that there's no distinction that can really be made between the shots that were fired, which were for counts 1 and 2, as opposed to the ones which are used to establish counts 4 and 5. So we still think, based upon the defendant's testimony, the state's evidence doesn't show that there's any intentional act that wasn't an essential element of the underlying charge, Judge.
Response from state.
Well, Your Honor, when it comes to the question of the defendant's version explaining it away, again, the jury can choose to disregard all or any part of his testimony, and I would suggest that his testimony actually bolsters the last 2 counts because he admitted he fired at the door in response to somebody opening it.
You get the last word if you want it, Mr. Schwartz. Yeah. The state has met their burden on counts 1, 2, and 3, and as to counts 4 and 5, the attempted felony murder counts, the issue of what he intended, first of all, you can't JOA intent, the case law is clear on that. And secondly, he admitted he fired at the door, which is, the jury has to decide whether or not that was an intent to kill. So I'm going to deny the JOA on both counts. And now, ladies and gentlemen, we need to talk to a juror. So if you could bring up juror 1471, please. I'm sorry? Oh, yeah. Sure. You ready, Jean? Good morning.
Morning.
Ma'am, did you make a statement in front of all of the jurors yesterday at dinner asking about the second case in this matter?
The deputy, we asked, somebody said that we are doing one half, and the deputy clarified that, and I asked, why are we talking about these things then? And then everyone was like, no, don't, and I didn't say anything else. So yeah, I guess.
Did you make a statement about why you all were not, did you ask the question about whether or not you all were going to be the jury for the second case?
I didn't ask that, no. Somebody made the statement.
And who was that somebody?
I don't know her jury number.
And then did you ask a further question?
And then I asked, why are we talking about that then?
You mean in the trial?
Yeah.
Did you hear my instructions that were repeated to the jury that you are not to discuss this case among yourselves in any way, shape, or form until you were discharged as jurors, or actually until you went back in that room to render a verdict?
Yes, it was an accident, I'm sorry.
And did you understand when I told you during jury selection that you may not tell anyone else on the panel anything that you may or may not know about Sergeant Clayton?
Yes.
And can you please explain to me why any of you, specifically you, were talking about this at all?
I never mentioned Sergeant Clayton or anything. Somebody brought it up, and then I asked that question.
Who brought it up?
I don't know her jury number.
And what exactly did they say?
They said that we were only the jury for the first half.
And how many people were standing there when you said that, or when they said that?
It was basically the whole jury.
And did other jurors comment on this?
No.
Do you
Not that I know.
Do you understand that you are only here for Sade Dixon, Ronald Stewart, Dominique Dixon, and Stephanie Dixon Daniels.
Yes.
Is there anything about Sergeant Clayton that you think is relevant to this case other than what I told you all, which was the evidence was offered for identity and consciousness of guilt?
No, I don't think it does have any. Wait, repeat the question?
The evidence about the Walmart is only being offered for the jury to weigh as identity of Mr. Loyd and consciousness of guilt
Right,
in
yeah.
Sade Dixon.
I understand.
Can you follow the court's instructions?
Yes.
Do you understand that the court can hold jurors, and is perfectly willing to do it, in contempt for violating the instructions in this case?
Yes, I do understand.
State, do you have any questions?
No, ma'am.
Defense? You can return to the jury room, ma'am. I would like to see juror number 1475, please. Good morning, ma'am.
Hi.
How are you this morning?
Good, how are you?
I'm fine, thank you. Ma'am, it has been reported to me that there was an incident at dinner yesterday involving jurors discussing the incident at Walmart. Is that correct?
That is incorrect.
All right, what happened?
Someone asked if after we were done deliberating, is that the end of the case? And I said, depending, it would just, whatever is decided, would we maybe go or maybe not? And that juror did not understand what I meant. And the waiter was in the room, so I waited for the waiter to leave. And then I asked the deputy, how could I explain this correctly for her to understand without emphasizing that there will be another jury after this that has nothing to do with why we are here.
Okay.
And that is how that went.
How many jurors were in the room when all of this happened?
I believe all of us.
Okay. Was everyone participating in the discussion?
I think there was some side conversations going on separate from that.
Okay.
But I believe that most of us were listening to understand.
Do you understand that the only thing that can be discussed by this jury is the evidence that was introduced about Walmart in this trial? Do you understand that?
I understand that that is not part of the charges that are being discussed in this case.
Correct. That what you saw about the Walmart is limited to the instruction I gave you, consciousness of guilt, identity, and that's it.
I understand that.
Okay.
I just couldn't figure out how to explain without talking about the case to the other juror.
I understand that, ma'am. Do you also understand that any knowledge you may possess beyond what you heard in this courtroom cannot be shared with the other jurors, even when you're in deliberations?
I never spoke about anything other than what was talked in this courtroom.
I have no reports that you did, ma'am.
Okay.
I'm just clarifying that the instructions are being understood.
Yes.
Have you heard any other jurors talking about any evidence concerning or the incident at Walmart beyond what was heard in this courtroom?
No.
Have you heard any other discussions about any of this outside of this courtroom and the incident at dinner?
No.
Okay. Has that influenced you in any way in making a decision in this case?
Absolutely not.
State, do you have any questions?
No, ma'am.
Defense? Thank you, ma'am. You may return to the jury room.
Thank you.
Is either side requesting that I continue the inquiry with the entire panel? State?
No, ma'am.
Defense? Either side have a motion. State?
No, ma'am.
Defense? All right. Both sides have rested their case. I'm going to bring this jury in. I'm going to instruct them one more time what the rules are. I'm sorry? You may. All right, both sides have now rested. Let's bring the jury back in so I can instruct them. Stay recognized, presence of the jury.
Yes, ma'am.
Defense? Yes. All right, folks, welcome back. What I'm going to go over with you the rest of the process for this phase. Both sides have now rested their case. That means you have received all of the evidence that you're going to receive in this case. We now have to prepare the jury instructions, and that is quite a lengthy process. So for today, you're going to go back, you're going to eat lunch, and then you're going to go back to the hotel. We are going to have closing arguments in this case tomorrow morning. You at that time will receive the instructions on the law that you are to follow in making a decision as to whether or not the state has proven this case beyond a reasonable doubt. You will get all of that in writing tomorrow morning, and we will start at 9 a.m. There seems to be some confusion, so let me go over this with you all one more time. You are not allowed to have any discussion whatsoever about this case until tomorrow when you retire to that jury room after I've read the instructions to you and after you've heard the closing arguments of the attorneys. That includes speculating about what may happen, what the process is, why, a witness wore whatever it might be. You cannot discuss this case. You cannot discuss any thought you may have about this case with anyone, deputies, each other, no one. Does everyone understand what I am saying? Talk about something else. If you have a question, if you are confused about the process, the person that you can ask is me. Write me a note. You guys are good about writing me notes. Write me a note. Don't ask a deputy. Don't ask each other. Don't talk about it. Are we clear? All right. Have a good lunch. I understand that today is pizza. Today is pizza day. So, have a good lunch. Have a good afternoon. Get some rest. At 9 a.m. tomorrow, instructions, closing argument, and then we're turning the case over to you for a verdict. All right? I'll see you tomorrow. All right, unless either of the parties has something else to discuss, we're in recess till 1:30. We're doing charge conference starting at 1:30 in this courtroom. I'll see you then. Court's in recess.